Welcome. Today we're going to discuss an opinion issued by the Trademark Trial and Appeal Board in the case of the BROOKLYN Brewery Corp versus the BROOKLYN Brew Shop. My name is Scott Slavick, and I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, or searching and clearing new global brands on a rush timeline, or reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In an exhaustive 70-page opinion, the board denied a petition for cancellation of a registration for the mark BROOKLYN Brew Shop and dismissed an opposition to that mark in stylized form for beer-making kits, ruling that Laches and Acquiescence barred the plaintiff's likelihood of confusion claims. In reaching that conclusion, the board found that confusion between the defendant's marks and the plaintiff's marks BROOKLYN and BROOKLYN Brewery for beer was not inevitable. The defendant's registration for BROOKLYN Brew Shop issued on October 4th, 2011 on an application that was published on July 19th, 2011. Plaintiff filed its petition for cancellation on December 10th, 2015. However, the plaintiff admitted that it first became aware of the defendant's use of BROOKLYN Brew Shop in 2010. Between 2011 and 2016, the parties collaborated on projects related to beer making, including co-branding beer making kits. Laches and Acquiescence are defenses available in trademark proceedings. Even if proven, however, these equitable defenses cannot bar a likelihood of confusion claim if confusion is inevitable, because any injury to a defendant is outweighed by the public interest in preventing confusion. Although the defense of Laches is generally not available in an opposition, since Laches doesn't begin to run until the application is published for opposition, the defense may be available if the applicant owns a prior registration for substantially the same mark and goods. Here, the defendant's prior registration of the standard character mark BROOKLYN Brew Shop entitles it to use the wording in any font style, including that of the opposed application. And so the board concluded that the Laches defense is available in this proceeding as well as in the cancellation proceeding. To establish the Laches defense, a party must prove 1, an unreasonable delay in the assertion of rights, and 2, material prejudice attributable to the delay. Because the plaintiff was aware of the defendant's use of the mark, Laches began to run on the date of publication of the underlying application, July 19, 2011. Defendant may also rely on that date for its Laches defense in the opposition. Plaintiff filed its notice of opposition about 4 years and 2 months later, and its cancellation petition about 4 years and 5 months later. The board found this delay unreasonable because the plaintiff undoubtedly had full knowledge of the defendant's activities during that time period. Moreover, the plaintiff's claim that its delay was justified by defendant's progressive encroachment was rejected by the board, since the beer-making kits sold by the defendant did not change over that period of time. Moreover, the plaintiff was aware of the defendant's nationwide sales, and so those sales could not be considered a low level of encroachment. The board found that the defendant suffered material prejudice because of the delay. It continued to grow its business, increased its advertising expenditures, published 2 books of recipes, and tripled its sales. Loss of trademark rights would have resulted in severe economic prejudice resulting from the defendant's delay. And so the board concluded that the defendant had proven Laches as to the beer-making kits. Unlike Laches, the defense of acquiescence requires some affirmative act by the trademark owner. To establish this defense, a defendant must prove that the plaintiff's conduct amounted to an assurance by the plaintiff to the defendant, either express or implied, that the plaintiff would not assert its trademark rights against the defendant. Acquiescence requires proof of 3 elements. 1, that the plaintiff actively represented that it would not assert a right or a claim. 2, the delay between the active representation and assertion of the right or claim was not excusable. And 3, the delay caused the defendant undue prejudice. In view of the defendant's public collaboration with the plaintiff, the board found that the plaintiff actively represented that it would not assert its rights against the defendant's use of BROOKLYN Brew Shop for beer-making kits. Moreover, the board found that the delay was inexcusable and that defendant was unduly prejudiced by the delay. In sum, the plaintiff's actions constituted a classic example of acquiescence. In determining inevitable confusion, the board applied the relevant DuPont factors. The board focused on the plaintiff's BROOKLYN Brewery and BROOKLYN marks in standard characters. It found, not surprisingly, that beer-making kits were related to beer and are sold in the same channels of trade to overlapping classes of consumers. Turning to the marks, the board found the plaintiff's marks to be inherently weak, knowing that they were registered with a claim of acquired distinctiveness. The plaintiff is located in Brooklyn, and the addition of the generic term brewery did little to bolster the inherent strength of the plaintiff's primarily geographically descriptive Brooklyn Brewery mark. However, the marks had achieved a degree of commercial recognition. Concluding that these findings offset one another, the board ruled that the marks are entitled neither to an enhanced nor a diminished scope of protection. Comparing the marks at issue, the board found them to be similar than dissimilar. Plaintiff asserted that the evidence of actual confusion was overwhelming, but the board disagreed. Although there were many instances of confusion, they were not entitled to the weight that the plaintiff ascribed to the evidence. Much of the alleged confusion occurred during the period when the parties were actively promoting the co-branded beer-making kits. Given the parties' co-branding of beer-making kits and joint participation in numerous marketing events, the court was hardly surprised that consumers could have been confused as to whether the parties were affiliated in some way. Simply put, although some consumers may have been confused as to whether the companies were affiliated, they cannot have been confused as to the source of the goods because both parties were in fact the source of the goods. Accordingly, the plaintiff's evidence from 2012 and later did not establish actual confusion among consumers. The remaining examples of actual confusion were too infirm to constitute evidence of sufficient probative value to support a finding of actual confusion. The standard of confusion for a finding of inevitability of confusion is an increment higher than that required for a finding of a likelihood of confusion. Generally, inevitable confusion has been found when the marks on the goods are identical or nearly so. Here, the evidence failed to establish that confusion was inevitable as to the defendant's beer-making kits. Neither the marks nor the goods were identical. The plaintiff's CEO said he had no problem with the defendant's use of BROOKLYN Brew Shop for the kits. If the plaintiff's CEO had no problem, confusion is not inevitable as to the kits. And so the board dismissed the opposition and denied the cancellation petition as to the defendant's Section 2D claims regarding beer-making kits. Plaintiff also sought cancellation on the ground that BROOKLYN Brew Shop was merely descriptive of the defendant's kits. The board noted that the defense of Laches and Acquiescence were not available against claims of mere descriptiveness. The board agreed with the plaintiff that the mark was geographically descriptive of the goods, since defendant is located in Brooklyn. But the plaintiff did not plead Section 2E2. The marks did not describe a quality, feature, function, or characteristic of the goods, and therefore they were not merely descriptive. The opposed application also included beverage glassware and sanitizing preparations. The equitable defenses did not apply to those goods, and so the board went through an ordinary DuPont analysis. As to the glassware, the board found confusion likely, since plaintiff also sold glassware, but as to the sanitizing preparations, the differences in the goods was dispositive. This case was terrific in terms of explaining the often confused differences between Laches and Acquiescence. They're often described in the same sentence or used interchangeably, but they are not interchangeable. The court also shows how difficult they are to employ. Clients often ask how long it takes before Laches or Acquiescence would apply, and that answer is often very difficult to answer. First, they may never apply depending on the circumstances of a given case, as this case explained. Second, lack of action alone is not always indicative of whether Laches or Acquiescence will apply. Third, even if they apply, they might not give the defendant what the defendant wants, which is dismissal of the action. This case shows that while these defenses are very helpful, they may not be the panacea that all defendants think they are. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.